Here at Case Western and director of the Center for Professional Ethics, which is co-sponsoring this next panel. This panel is going to talk about ethical principles and corporate social responsibility as limits on corporate human rights violations. We have a wonderful panel of professors here. We're going to start on my right with Kish Perella, who is an associate professor of law at Washington and Lee School of Law. And she'll be talking about brand as information intermediary. After Kish, we will have Professor Caroline Cabe, who is an assistant professor of business law at the University of Connecticut School of Business. And she'll be talking about corporate morality and public policy, the new frontier of ethical business. And then finally, we will wrap things up with Professor David Nersessian, who is an assistant professor in the Accounting and Law Department at Babson College. And he'll be talking about a human rights perspective on professional responsibility in global corporate practice. So welcome to the panel, and we'll start with Kish.
Okay, thank you very much. I'm honored to be here. My presentation is really about matching our regulatory strategy for how we regulate corporations to the realities of global production. So just in a nutshell, my whole point is that we have a strategy for regulatory design, how we go about regulating businesses, that may not match the way they actually operate in their supply chains. And if we actually matched our regulatory design to the production change, how would we change our strategies? Okay. So what's the problem? Well, we know that many of the products that we buy are made in global supply chains. So think about all the brand products you buy, the classic example being Apple products. And as the public increasingly appreciates that the products we purchase are made in global supply chains, there's a demand for more information about what's happening in these supply chains. And we hear about a variety of human rights violations. And so really the concern is about more information. How would we gain more information regarding what happens in the supply chain? Because information is productive and can lead to different types of pressure for reform. There are at least two information forcing strategies that litigants and legislators have used. One is civil litigation. And so for example, we talked a little bit about, but there are lawsuits, a variety of lawsuits against corporations regarding disclosure. So that in California, a number of litigants have brought cases against chocolate companies for failing to disclose on their candy wrapper that these products may have been made with child labor. And so they want these kinds of disclosures at the point of purchase so consumers can know. Other types of information forcing strategies are mandatory disclosures, like the California Transparency in Supply Chains Act of 2010, that require certain companies to make disclosures on their websites regarding what they're doing to basically their due diligence regarding a number of types of human rights risks. But the common theme with all these strategies is that they treat the multinational corporation as the primary subject of information disclosure. In other words, we treat the corporation as the primary actor whose behavior we want to reveal. But the reality is that the Apple supply chain, for example, involves a variety of suppliers, a variety of different actors that supply component pieces that manufacture them and that assemble them. So for example, by 2011, Apple neither manufactured the components nor assembled them into a finished product. They came from a variety of suppliers, and the assembly was carried out by Foxconn. The lion's share value in the supply chain is still Apple for what it contributes: research and development, marketing, shipping, and software development. But it's a different reality about who makes the products that we're purchasing. And given this composition of the supply chain, what is really the function of Apple? Well, you could take Apple or maybe extend the example. What if we had, let's say, Acme Corporation? And Acme Corporation has outsourced all its main functions for its products to a bunch of different actors. What is the role of Acme in this type of exchange? And I argue it's reputational capital. That basically what Acme is doing, or Apple, is that it's using its brand to bring together two different sets of actors, buyers and sellers. In other words, when we interact in the marketplace, we face something called information asymmetries. The sellers of products know way more about their products they're selling us than we do, because they're the ones who put it together. And there are types of information asymmetries that exist in domestic markets, but they're magnified when we think about international markets, because we don't know these actors who are manufacturing the component pieces or the goods that we're buying. So we might be fairly reluctant to go ahead and purchase those products if it wasn't for a middle actor that steps in and acts as a bridge, using its brand or its reputational capital to bring two actors together. And so that's what I'm kind of arguing Apple is here. Apple, when we buy a product, or let's go to Acme Corporation, these brand companies are not our primary exchange partner. We're not primarily exchanging with them. Instead, there's something called an information intermediary. And it's not the first time we've had these actors serve these roles in long-distance trade. In fact, there's been a fair amount of work in economic history regarding the role of information intermediaries in the 11th century, when we have long-distance trade and we have these situations of difficulties verifying, difficulties monitoring. You have these actors arise that serve as information intermediaries and use reputation to basically assuage the concerns of one group of people regarding another group of people, and an exchange happens. So if we change our view of Apple's role in the supply chain, and not as the primary exchange partner, but as information intermediary, how would that change how we regulate it? Right? So if we realize that it's not Apple that we're primarily exchanging with, how would we change how we regulate that information? And so I started thinking about, well, what other situations do we have this happening? Are there other situations where information intermediaries bring together buyers and sellers? And yes, in corporate law, there are situations wherein we rely on a variety of reputational intermediaries to assuage concerns of buyers and sellers. And there's a body of law called Gatekeeper Liability, which I'm not going to unpack here. But the whole idea is that in the securities markets, for example, auditors and securities analysts verify or assess corporate disclosures. They play important information intermediary roles because they're standing behind the statements of their corporate clients. And these actors derive less benefit from fraudulent disclosures compared to their clients, so they're easier to deter. So they're easier to apply pressure to get them to deter their clients from wrongdoing. So in other words, there are actors who possess significant reputational capital. That is their chief asset. And we have tried to apply pressure to them to, in a sort of a domino effect, deter their clients from wrongdoing when public actors cannot reach the clients to deter them effectively directly. So in these situations, so can we borrow the regulatory insight from that context to the situation of the supply chain? Can we similarly see, well, in that situation where there are actors with reputational capital, that's their chief asset, and their primary role in the exchange is to bring their reputational capital to bear, to bring together buyers and sellers, how could we use the insight from that regulatory design to the problem of the supply chain? And that's what I'm sort of struggling with now. So what? Part of it is conceptualizing what the problem is. That we see Apple as more of an information intermediary, how would we regulate them in terms of bringing information, shining a light on the supply chain, if we think about them in this role? So part of the takeaway, I think one part of the answer, is to think about incentivize. How do you appropriately incentivize one actor to take action in its supply chain to deter wrongdoing? And this is a basic point. It's about incentives. But it's important to think about, well, if reputational capital is their chief asset, it's also a big weakness, right? So the brand, the reputational brand, is going to be a really big carrot or stick, the way you conceive it, of how to motivate them to take action in their supply chain. And that connects back to how we do this. So all we have to think about is that the reputational brand damage has to exceed whatever benefits they are gaining from violations in the supply chain. And the brand damage varies by supply chain and how information comes out. So in other words, different information forcing strategies exert a different level of brand damage. They're not all the same. So even though civil litigation or mandatory non-financial reporting or various other information strategies give us information, they can exact a different level of brand damage. So you could think about information enforcing strategies as having two functions. One is purely informational, telling us what's going on in the supply chain, and the other one we could think of as an organizational change function. To what extent is this information, once it's out in the public, once it's in the hands of key stakeholders, is it going to incentivize actors to change their practices? So even if these information sharing regimes, okay, so we have all these different types of information forcing strategies, are equal in the first function, revealing what's going on in the supply chain, they might not be as equally effective in the second function. So part of the takeaway is thinking about these two separate functions. And in terms of impact, why does this matter? Well, part of it, I think, is the argument in favor of regulatory pluralism when we think about how we want to approach it. In certain contexts, the due diligence and mandatory reporting is gaining favor, and I do think it's really important. But there is significant work in communication studies and in other types of business studies about how different types of information have different levels of effects on brand reputation. And I think that we need to be aware of that if we want to create an incentive structure that works. So we don't want to crowd out all the different information strategies, given that that might vary with the brand. And the supply chain is highly context specific. And of course, one other limitation is that not all supply chains are the same. So I gave you Apple's supply chain, and then I talked a little bit about Acme. And so the role of a brand company in its supply chain is going to vary. And so the levers you use obviously are going to vary as well. But the key takeaway, or the key point, is that when you see a brand company not as just the primary actor, but as an information intermediary, there are different carrots and sticks you could use because of their role in their role in the exchange that is different than if you were exchanging directly with the manufacturer. Okay, that's all I'm going to say now. Thank you.
Thank you. All right, Carolyn?
Well, thank you so much for having me today. So I just told our moderator that I'm so glad that to see a panel on moral responsibility in an event like this in a law school. I have myself spent many years at Northwestern Law, so I'm very familiar with the legal scholarship and legal education, and I'm currently actually a faculty member at a business school. So what I am looking at in my current appointment is the intersection between business law and human rights in terms of legal requirements and mandates, right? But also in terms of moral responsibilities as a function of business ethics and how this should inform corporate behavior. So that's what I want to talk today in my talk, and I very much look forward to engaging with you in a Q&A, since, as you will see, these are very timely issues, highly controversial and heavily debated, especially in the current political environment. So that being said, while of course, and that's just to stress this from the onset, litigation, accountability, transparency, right, what we have just heard about, are absolutely indispensable baseline criteria to ensure responsible business conduct with regard to human rights, but also other important standards, labor standards in supply chain, environmental standards. I do believe there is an important additional complementary dimension of corporate responsibility, which has been somewhat neglected in recent years, where this area of corporate responsibility has become more and more legalized, right? More and more regulated. We see more and more mandatory reporting requirements or voluntary disclosure of non-financial information, ESG factors, or in France right now, we have seen the adoption of a new law that provides for a mandatory due diligence requirement for companies. So keeping all that in mind, I do believe it is important to kind of take a step back and think about, okay, while this is all a great development, in addition to that, what is the moral responsibility that corporations have today? And how do they display and discharge of that moral responsibility or not? And what are the implications for companies, their bottom line, but also what are the normative implications for corporate law, for international standards that are out there on corporate responsibility, on business and human rights in particular, with reference to the UN framework on business and human rights and the UN guiding principles spearheaded by John Ruggie at the time. So, of course, absolutely recognizing that corporate moral agency, right, is a subject that has been discussed at length in the scholarship, and I'm not going to go into the details and the challenges, right, of corporate moral agency. I know it has been touched upon in the morning to some extent. It's not easy to establish corporate moral agency conceptually by any means or from a philosophical perspective. But what I want to focus on today is really a recent phenomenon of corporate behavior and what the normative implications of that new trend, if it might be a trend, perhaps it's just a temporary pattern, would be. And that phenomena is corporate executives using their corporate voice and influence to proactively steer public policy for the advancement of societal values and human rights. What sounds very, very grand, but of course there is a healthy cynical view of how corporate behavior intersects with public policy, right, which is usually and traditionally in the form of lobbying, where corporate interest is pursued in a more narrow way. And that is not what this talk really focuses about. What this talk looks at is really the intersection between business and human rights and how it has manifested itself in recent headlines. I'm very sure once I give you a few of the nuggets and examples, you will recognize many of them. Just to state, in terms of business and human rights, this is not a new area by any means. It's already in 2014, the Economist Intelligence Unit has done a survey of about 880 corporate executives, top executives. And they have asked them, well, do human rights matter in your business practice? I mean, it's business, right? Business and human rights, that seems like very different creatures, right? Public and private. And so surprisingly, this survey in 2014 has yielded that 83% of corporate executives that were surveyed agree that human rights are a matter for business as well as government. And of course, that is not a new assertion, right? The UN, under the mandate of John Ruggie, has said this since the mid-2000s, right? But it's a different level to have corporate executives actually state, yes, human rights, this is something that we think about, not in 50% of our time, but it occupies a good amount of our time in decision making, especially when we think about how to engage on public policy issues, especially pressing public policy issues. In some of these areas where CEOs, especially in top management, have used the corporate voice and have taken a stand, are areas, again, of significant public importance at this time. They include issues like LGBT rights, climate change, very recently white supremacy, immigration, sex discrimination, sexual harassment, thinking about the case of Uber very recently. So these are really examples of corporate leadership taking a different path to their leadership. That is not only corporate leadership, it's really also entailing political, social leadership, right? So in other words, just being leaders, period. There was an article in the New York Times very recently in mid-August that really hit the nerve of that phenomena, and it totally went viral, at least in my field, you know. And it was titled, "The Moral Voice of Corporate America." So what are a few examples of this moral voice of corporate America that we have heard more recently, especially since beginning of this year and under the new administration? Examples are corporate responses to the president's immigration ban as early as January, including Starbucks' commitment to hire 10,000 refugees, strong reactions by Silicon Valley leaders, including Netflix CEO calling the actions un-American, and other major ICT companies echoing the sentiment. Another example is major companies pulling their investments out of states with discriminatory LGBT laws, especially North Carolina, Mississippi. Can just give you a personal example. My own home organization, the University of Connecticut, has still a travel ban in effect with regard to North Carolina to not expend any state funds for faculty to travel to North Carolina because of their discriminatory LGBT laws. So that remains a timely topic. Another big issue of societal importance that has attracted the attention of corporate leadership, climate change. 365 companies and major investors have pleaded to the president not to abandon the climate accord and have reaffirmed their commitment to reduce their carbon footprint. We know how that has turned out with regard to the Paris Climate Accord. And two other very recent examples, and I'm going to conclude my list of examples with that, are the reactions regarding the rollback, the cutback of DACA. 400 CEOs signed a letter to the administration and Congress to save the program. And then, of course, very recently, and I'm very sure you have seen this in the media and the headlines, on many counts, the reactions by corporate executives in light of the president's remarks in face of the Charlottesville violence, blaming many sides, thus equating white supremacists with those protesting them, which has led CEOs of major companies such as Intel, Merck, Under Armour, IBM, General Motors, just to mention a few, to actually resign from the president's advisory councils. And I just want to give you one short quote by the CEO of Merck, who has put out a statement where he states as follows: American leaders must honor our fundamental values by clearly rejecting expressions of hatred, bigotry, and group supremacy, which run counter to the American ideal that all people are created equal. As CEO of Merck, and as a matter of personal conscience, I feel a responsibility to take a stand against intolerance and extremism. And what is interesting, and this is just one example, I mean, if you just Google it, you will just see many quotes by CEOs, presidents, chairmen of companies, major companies. And what is interesting is somewhat of a reoccurring pattern of making reference to a moral responsibility. What we have seen more in the past in the area of corporate responsibility is companies trying to make the argument that it is in their best interest, right, in terms of their business and their shareholders, to care about their reputation and do the right thing. But this is really a change in tone that does not use that intermediary step, but it is really a clear commitment to moral responsibility and to display that and do so very forcefully in that context. So as you might have realized by now, these are primarily US examples. So one could say, well, perhaps it's just a US phenomena, right? Because of the political environment we're in right now. And perhaps it's also a US phenomena because corporate responsibility and the notion of corporate responsibility is very different in the United States than, for example, in Europe, where corporate responsibility is more regulation-based, whereas in the United States it's more business-driven, it's more investor-based. And while there is certainly some truth in that distinction, and I've written about this in the past, I really do believe there is kind of a common thread, which we also see in Europe, not with the same force, but we do see it, for example, corporate responses and initiatives of 36, for example, German companies joining together to promote integration of refugees in light of the Syrian refugee crisis, which has been a major challenge for European countries and businesses alike. So is this a trend? We don't know yet, but it is certainly a pattern that we are seeing. And so it does merit some thinking about what does this mean in terms of the notion of corporate responsibility and business and human rights as we understand it today. What is also important to note is that these expressions of moral responsibility on part of corporate CEOs, they do not happen in a vacuum, right? What many have noted, one of them being, for example, Tim Cook from Apple, and I think very rightly so, he has pointed out that we see significant governance gaps in capitals around the world, right? Governments failing to address major issues in their societies, legislators being gridlocked. And so the pressure is really more on the business sector, and as Tim Cook, the Apple CEO, has put it, and so it does fall, I think, not just on business, but on all other areas of society to step up, which is something that is actually confirmed by empirical data. Edelman, a major PR consulting firm in the United States, does a survey every year in 28 countries. They have done it for 17 years, where they measure the status of trust globally. Trust in institutions, trust in government, in business, in media. Where are we at, right? What's a reality check on the trust barometer? And so what Edelman has found for 2017 is a steep decline in trust in the entire system with all its 4 institutions, government, media, NGOs, and business. Actually finding that the levels of trust are at an all-time low globally. Again, this is a survey across 28 countries. What they do find, though, is also that business is not in as bad shape as is government, but, quote, business is on the brink of distrust. So in other words, business is on notice, right? Business needs to rise to the occasion. And then also business as the last retaining wall. That's kind of their statement. That's what Edelman found. Not only that the stakes are high for business, but so are the expectations that business actually will stand up and speak up to promote human rights, advance human rights, and not merely to respect human rights, which of course is an indispensable baseline criteria. And for all of you who have taken an international law course or human rights course, you know that respecting human rights means to not do harm, right? You don't violate human rights. To protect or promote human rights, that's kind of a level beyond that, right? So just a few words in my last 5 minutes on giving you a normative perspective. So what are the normative implications of this phenomena that we have seen? Might be a trend, perhaps not. But what would be the normative implications? I believe they would be twofold. One question that we have to ask ourselves is, how does this phenomena fit in with the existing corporate responsibility doctrine? Corporate responsibility is really an umbrella term. It can include many different ways of companies interacting with society, including philanthropy, right? We all know philanthropy, corporate charity, but also creating shared value, according to Michael Porter from Harvard Business School, right? In terms of social enterprise. So in other words, finding a business model that solves a societal problem but still is profitable, right? Compliance. We know that very well in law schools, right? Respecting human rights, compliance, do not violate laws, comply with anti-corruption laws, environmental standards, labor standards in supply chain. So that's another area. And then, again, I do really believe this new development in business practice that we are seeing, or in corporate behavior, not business practice, but corporate behavior, brings back moral responsibility, which for which especially a human rights lens is going to be helpful, because human rights, and I think we also have to remember that, and it has been sometimes ignored in the legal literature and also in the business ethics literature. Human rights are political rights, they are legal rights, but they are also moral rights. And there comes a moral responsibility as well for government, but perhaps also at this point also for businesses. Of course, as some of you might know, the United Nations has provided some framework for business and human rights, where they have found that there is a corporate responsibility to respect human rights. So not to do harm, not to violate human rights, to not use child labor, right? Not use forced labor, to not discriminate based on gender, sex, ethnicity. But what they do not speak on, these UN guidelines or guiding principles as they are called, they do not provide guidance on how companies should engage proactively with public policy in order not just to respect human rights, but to advance human rights and societal values. To conclude, what I do think is an important takeaway here is, to say it with the words of Howard Schultz, chairman of Starbucks, not every business decision is an economic one. And that is really the new mantra of corporate leadership. Not every business decision is an economic one, but the decision to engage on a certain topic, LGBT rights, climate change, discrimination, can well have economic impact on your bottom line, directly, indirectly, long-term, or short-term. We see this, and I have just looked at some material from my research assistant this morning in preparation for this conference. We see this especially when companies get it wrong. You see the stock price go way down. Think about Uber, United. It just totally, I mean, you can really see the drop. Do we see a clear rise in your stock price if you get it right? That's a little bit more tricky and less clear, but you can't get it wrong anymore in 2017. I think that is kind of a clear message. So you might not want to engage on these public policy issues, but you have to make a decision, and it's a managerial decision, and part of your managerial decision making that you have to make, whether to engage or not, and it will have impact whether you engage or you do not engage. So I would like to close with that and look forward to your questions.
Thank you so much. David?
Thank you. So as I was thinking about this, I was trying to ask the question, what do human rights and legal ethics have to do with one another at all? And in thinking about that, I thought the most useful way to think about it would be to start really broad and then kind of narrow down from there. So if we take a big step back conceptually, what we see is that human rights present a complicated mixture of values and aspirations. What is best in humanity, combined with serious operational challenges in terms of how we achieve that and what the consequences are for failing to live up to those standards. Same thing in legal ethics, same thing in the rules of professional responsibility. You know, we're lawyers, or we aspire to be lawyers, and it is an aspirational profession. I mean, no one gets into this because they really are just dying to one day have to comply with Model Rule 1.7 on conflicts of interest, right? People get into this because of the aspirational aspect of it, the idea of justice or changing people's lives or contributing to the social welfare, right? But you need the rules of legal ethics to help achieve that, and also to provide consequences when people don't, when they don't live up to those standards. So that's the wider setting. When we think about corporations, we think about bad corporate behavior, right? A certain transaction, a series of acts that we would characterize as illegal, right? We regulate that in multiple ways. One of those ways is through the criminal law system, right? There are certain behaviors that corporations engage in, whatever they are, that is, we will say, is a corporate crime, and both the corporation and individual actors within the corporation can be held liable for that. Then we have the civil law system that applies at the same time. You can take that same course of action, and it can have civil consequences in terms of creating a legal obligation to pay compensation to people who are hurt by it. That could be a shareholder activity. There's the shareholder saying that because the corporation did this, its value was diminished, therefore people have to pay for that. But there's some kind of compensatory element to it as well. The third area is the administrative regulation. That also applies. As was pointed out at the end of the last panel, I think the Anderson case is probably a really good example, because it was not the criminal conviction that led to the demise of Arthur Anderson. It was the fact that because of the criminal conviction, they were no longer allowed to audit publicly traded companies. And therefore, they had to, as a result, all of their business disappeared and 85,000 people lost their job. Right? So the regulatory aspects matter a lot. Those administrative consequences can be very, very severe, even worse than the criminal conviction itself. That goes for everybody. That goes for all corporations. That goes for all corporate actors. No matter what your function within the corporation, all three of those things will apply to you. So what makes lawyers different? Lawyers have two additional things that they need to be thinking about. Number one is, on the civil side, is malpractice liability. And particularly for thinking about like in-house counsel, that sort of thing. As in-house work is becoming increasingly sophisticated, a lot of companies have decided they don't want to pay big firm rates anymore, so they're actually bringing lawyers in-house. So as in-house lawyers, as in-house counsel are shifting from sort of managers of legal services provided by others to direct providers of legal services to the corporation, you're actually seeing malpractice cases being brought against general counsel, being brought against in-house counsel. You didn't get the patent correctly, you didn't get the securities correct, whatever it happens to be. So you're seeing that as something that now, within those other three areas, lawyers have a special thing they need to worry about. Also, what I'm going to really talk about today, the disciplinary system. By virtue of being a lawyer, there is a separate and independent regulatory system that follows you around all the time, whether you're practicing law or not. If you're licensed, it applies to you and it regulates your conduct, and there are significant consequences for running afoul of those rules. So the question is, so how is it that intersects with international law, right? How is it that human rights violations by corporations can get lawyers in trouble with the bar? So I'm going to draw upon the US rules as examples. For now, that's really just for convenience. Most countries have their own, have very similar provisions. They might draw the line in different places, but typically the underlying concepts are similar, right? So there's three primary areas of risk. First area is what I call risks that arise from the object of representation itself. Right? We have a rule, 1.2d. It says that lawyers cannot assist their clients in perpetrating criminal or fraudulent conduct, right? Seems sensible, right? We don't want lawyers helping people to commit crimes. All serious, the conduct that constitutes serious human rights violations also is criminal under most legal systems. And you can think about it really in two ways. One is sort of the really clear cases, right? So conduct amounting to torture or war crimes or crimes against humanity, the stuff that you see in the ATS cases. That certainly would qualify. The harder cases are what fall into the category of what you call the dual use problem. So someone who has a legitimate chemical that their company manufactures, but then they're selling that chemical to someone else knowing that they will use that to make chemical weapons or for some other kind of illegal purpose. Those cases are a lot harder. The recently retired Judge Posner in the Seventh Circuit said, well, listen, if you push this analysis too far, then you're going to have to arrest shopkeepers who sell a short dress to a prostitute for aiding and abetting that crime, right? So there's an analytic end to that. But within that, the concept still holds, right? Zyklon B, which is used to kill people at Nazi concentration camps, was a legal product. It was a legitimate product. It was an insecticide. But it was the use to which the Nazis put it, killing people in showers, as opposed to fumigating areas where people were living, that is what made it illegal. And there were several individuals, Bruno Tesch and others, who were convicted of helping them to do that, who were business actors who were convicted of helping the Nazis to do that, right, with that legal product. That creates multiple problems for lawyers, specifically. Lawyers obviously have been prosecuted for helping their clients with crimes. There's no reason to think that if the ICC does decide to focus on corporate conduct, that they're going to be looking at the high-level leadership team of corporations, and certainly the general counsel's office is going to be in that crosshair as well. I think there's no doubt about that. But apart from that, it also creates an obligation for the lawyer that's separate from their own risk of liability for being prosecuted. In particular, they have to withdraw. Rule 1.16 says you cannot continue a representation of any kind that would violate the ethical rules of professional responsibility or other laws. In some jurisdictions, you have to do what's called, actually there's 40 jurisdictions, you have to do what's called a noisy withdrawal, meaning if your legal work was used in connection with that, you have to basically step back and say publicly, you can't use that work, I'm stepping away from it, I no longer support that opinion, whatever it happens to be. But it is a violation of the rules of conduct, or Rule 8.4. It's professional misconduct to commit a criminal offense, or that's focused on the underlying conduct. Even if that conduct is never prosecuted, the fact that you engaged in it is enough to fall under this rule. So there have been lawyers who've been acquitted of crimes. There have been lawyers who have been, given immunity. There have been lawyers who have been given pardons. They have still lost their law license arising out of that factual circumstance. So it's a risk to you as a lawyer in a way that it wouldn't be to any other corporate actor. And apart from that, that specter of corporate liability creates a conflict of interest. Right? We have a rule, Rule 1.7, governs how conflicts are handled, and you have a conflict automatically in that circumstance. So the upshot there in this area is from multiple perspectives, you have to withdraw. You cannot represent a client who's engaged in this activity. That's the first thing. Second area of risk is related to professional secrecy and confidentiality. The attorney-client privilege does not attach to criminal conduct, and that would include things that would amount to international crimes. Rule 1.6 has some exceptions to the confidentiality rules that you can reveal information relating to the representation to prevent death or serious bodily injury. Again, most serious human rights violations would fall within that category. And it doesn't have to be conduct by a client. It could be a client supplier. It could be a client's joint venture government or something like that that is engaged in this conduct. You can reveal under this Rule 1.6. Different states draw this line in different places. Some really focus it on criminal conduct, but some also have mandatory reporting, meaning it's not even up to you anymore. You have to report it if it's a crime of violence that would involve death or serious bodily injury. There also are special rules that apply in the corporate context. We have Rule 1.13, which like Sarbanes-Oxley, was put into place after Enron. It supplements the obligations under Rule 1.6 and basically says that the lawyer represents the corporation, not the individual officers and directors and employees of the corporation. They represent the entity, and the obligation is to protect the entity. So if you have an employee or officer who is breaching a duty to the organization, who's violating the law in a way that can be imputed to the organization, or who is engaged in other conduct that's likely to harm the organization, the lawyer must report it upward to the organization. You can't ignore it. You have to take steps within the organization to prevent that from happening, right? Reporting all the way up to the board. If the reporting upward is unsuccessful, the lawyer has the option to reveal to an outside agency in order to prevent a substantial injury to the organization. You say, well, what's a substantial injury? I think probably, I would say, human rights violations fall into that category. If for no other reason than if you look at surveys of CEOs, what are the top 5 things that you're worried about this week? Corporate reputation always shows up in the top 5. There are estimates that about 30% of the value, the corporate value of the S&P 500 is brand. That's a huge amount of money. And obviously, any human rights violation can be a really serious hit to the brand. So I think, in my view, it certainly would qualify as substantial injury to the organization for a company to be engaging in this behavior. The third area of risk is risks relating to other lawyers. Two types of these. First of all, senior lawyers have supervisory obligations. under rules 5.1, 5.3. And what that means is that there are certain circumstances under which another lawyer's violation of the law, the rules of professional conduct, becomes your violation of the rules of professional conduct. So you can be held liable derivatively for someone else's conduct. And that would include foreign lawyers, right? If you're engaging in a transaction, a foreign lawyer is doing something that they shouldn't be doing, there are situations in which you can be held liable for that. That's a significant risk. But then also there are circumstances under Rule 8.4 where you're obligated to report misconduct by other lawyers. And again, that's a situation where conduct that you aren't even necessarily involved in, but which you become aware of, now you have an obligation to report it to the bar authority. And if you don't, you have committed a disciplinary violation. Right? So these are risks, right? These are risks as you're doing your thing, as you're representing, you're engaged in corporate legal practice. These are things that come up for you. But there are two other points that I think are worth mentioning. And one is operational, and the other one is aspirational, kind of that same paradigm that I started with. The operational point is that this is a moving target. It requires lawyers to really constantly reconsider this. And I'll give you an example. So Myanmar. Sanctions were lifted against Myanmar about a year ago. And as a result, a lot of companies started now looking at Myanmar as a potential place that they would want to do business. Right? As of a few weeks ago, the Myanmar military government has engaged in a very serious crackdown against minority Rohingya Muslims. That it really looks from the outside to be that they're committing crimes against humanity. You certainly have a lot of bad stuff happening because you have at least 400,000 people as of yesterday who had crossed the border into Bangladesh, fleeing that situation. You very well might have sanctions put back on Myanmar. So this is not something you're never gonna, you will never in this area, you have the chance to run across the touchdown line and do the Gronk spike with the football, right? You'll never be there. This is a constantly evolving situation, and you need to stay on top of it as a lawyer. It's your responsibility in terms of your obligations to your client, to the corporation, to make sure that you're monitoring this in an ongoing way. The other point, the last point, this is the one I'll close on, is more of an aspirational point. And this comes from a really terrible anecdote that I read about. There is a company called Topf & Sons, and they were an engineering firm, they're a German engineering firm, and they made industrial equipment for the German government, German industry, before, during, and after World War II. And that included industrial crematoria for use in concentration camps. And they came up with an innovation. And what they found is they came up with this innovative design that actually used the body fat of deceased individuals to help fuel the cremation process. So it was a more efficient design. Once you got it going, the bodies burned and they kept it going themselves. You could use less fuel and save money. It was a more efficient design. Well, as a product, it failed because it turns out that when you starve people to death, they don't have any body fat and the oven didn't work properly. But the thing that I found really disturbing was that Topf & Sons subsequently patented that design in the 1950s. And some lawyer, someplace, helped them to do that. And I really think that that anecdote is really useful to think about because we are part of a profession that at its heart really has fundamental aspirations of justice, of fairness, of really making society better. And, you know, apart from the rules and the potential liability and staying out of trouble, you know, lawyers really should, you know, I think do some hard thinking about the kinds of matters that they become involved with in the first place. And it is entirely proper to do so, right? I've got a rule for that too, right? Rule 116b4 says it allows a lawyer to decline representation or withdraw from representation if the client persists in a course of conduct that the lawyer finds repugnant or about which the lawyer has a fundamental disagreement. And I would hope that human rights violations committed by corporations would fall under that rule in both of those. So I'll leave it there. Thank you.
Great, thank you so much. Really interesting thoughts from everybody on the panel. I I want to take a few minutes to have some sort of interpanel discussion because I think there's a lot of synergy between these projects. And then at 1:45, we'll open it up to the audience for questions as well. But I wanted to start out actually asking a question to both Kish and to Caroline, I think, together, because I think there's some really interesting overlap in the things that you all are looking at in terms of corporate social responsibility. But one of the things that struck me in terms of corporations becoming more involved in human rights issues, in social responsibility issues, is sort of a fear that we will see segmentation in the marketplace the way we've seen it in the political system. So, this has been one of my obsessions, right, since the election in November, is that it seems like there is this very deep political schism within the United States and huge distrust between the parties. And to a lesser degree, I think that is somewhat reflected in the corporate world. And so, yes, there have absolutely been corporations who say withdrew from the Trump Economic Council after Charlottesville. But there are also corporations, Chick-fil-A comes to mind, that donates significant amounts of money to anti-LGBT causes. Or the pizza company that donates money to try to lobby against reproductive rights issues. And I have this fear that we'll see market segmentation along political lines in corporations. Is that a risk that either one of you see, and how would you characterize that in terms of your frameworks? Kish?
Okay, sure. So I think that really ties into a fundamental question. I think what Caroline's describing is exciting and it's interesting and something to investigate. But I think what your question goes to the heart of is the drivers, right? The incentives. And maybe I'm just a cynical person now, and I was an optimist earlier, and maybe I'll be an optimist again. But right now, I want to know the why. And in the traditional forms of CSR, there are documented drivers that we have somehow generalized, drivers for the types of philanthropy and other types of things. And I wonder if those drivers can explain the public policy-driven CSR that you're describing here, and if those drivers are the same or are they different. If they're different, I think we need to know. And the two drivers you sort of talk about is this moment that we're in, a moment of heightened distrust and this parallel expectation. So are these temporal conditions? Are these conditions going to be, is it just a moment or is it going to pass? And we need to know that if, for a cynic, they're only responding to certain types of incentives. And I think the drivers are important because we can go, I think they help us evaluate the desirability of what Caroline is, and we're witnessing ourselves. And we might not care about the motivations or the internal drivers as much in other types of CSR, where we only care about the effects, like why do they give? Okay, fine. Maybe it's only the effects we care about, but here it might, because it's a public policy function, we might care about those internal drivers more, and also it can help us manage our expectations of whether this is something that's going to stay, right? Like why now? And is it just going to categorize this particular moment, or is this going to be something more permanent? So I think it's a driver's question.
Caroline, how would that fit in with your construct?
Yeah, I totally hear you. And of course, I have been thinking about what are the reasons, right? Because that is important, as you say, right? Is it just the moment, or is it really a broader shift? Or is it just a current phenomena, which might well be the case, right? So I do agree. It is important to ask why. And in order to do that, I do think while normative analysis is really helpful, what we need to do is really to talk to those who make the decisions and understand them better, right? And through empirical, also qualitative empirical research, not just quantitative, but qualitative empirical research, to really get a sense of what drives you decision making, because that shows how robust it will be, right? And if it's if it's just the flavor of the day, right? Oh, this is what my customer base cares about today, and that's fine. And tomorrow it's something else. That's one thing. The other thing is, I do think, and I have to admit, I haven't done that yet in terms of a full empirical analysis, but I do think even with the statements and expressions that are out there, it would be worth looking at those statements, doing even a linguistic analysis, right? And look at, okay, what did this look like a year ago, 2 years ago, right? And that can perhaps give us some clues as well, right? Of course, also that being said, I think it's probably more than one factor. It's certainly the moment, right, in time that we're in. Is that moment going to be temporary or permanent? We don't know yet. It's also, of course, a huge reputational angle, right? I mean, that's undeniable for companies, right? I mean, and I do think it's not a surprise that certain sectors, companies in certain sectors speak out more than others. I mean, I always have felt that, and in my experience, the ICT sector is just more vocal on some of these issues, and I do believe there are reasons. I mean, which are multifold, but one reason is that their entire business concept is built on trust, right? That we trust our data to them, so trust is important, and that goes beyond just corporate leadership. It goes towards political, social leadership. Where do you stand as a company? Because I give you all my information, right? I mean, so I want to know that you are a moral agent that I can trust, right? Whereas with an extractive company, we're like, yeah, well, I might, bad, but what am I going to do? I need to put gas in the tank, right? It's like, so I think it's kind of the expectations are a little bit different, right? And it's just more connected to their core business to some extent. Then, as a final note, and I don't know, perhaps it's too romantic and too hopeful, but if we look, of course, to the business ethic literature, especially integrative social contract theory, which has been promoted by Professor Donaldson at Wharton, one would assume or work on the premise that there are certain hyper norms, right, that would be universal norms and values which should steer corporate conduct. Hypernorms sounds, in its essence, right, are these universally acceptable norms and values across different cultures, jurisdictions, and countries. So sounds very similar to the concept of human rights in its universal nature, right, and universally prescriptive nature. So that, I guess, would be the more philosophical approach that one would hope for. But yes, I guess a healthy skepticism is always advised, of course.
And I love that idea of doing the linguistic analysis on statements made by corporate leaders as corporations engage in this kind of activity. Law students who are looking for note ideas, that would be a fabulous one, trying to sell it. David, did you want to add to that too?
Yeah, one thing that kind of got me thinking about is, are there objective ways to measure the level of a company's commitment to this? I mean, obviously there's sort of the risk avoidance and that sort of thing. But there are now corporate structures that allow for the public welfare, public benefit to be equally valid in the corporate charter with making money. And that there is no claim by the shareholders that you are violating a duty to the corporation if you choose the public welfare route. We're going to make less money this year because we're going to pay our employees more, or whatever it happens to be. So you could reflect that in your corporate charter. But I think that might be too great of a step for a lot of companies. But I think you could honestly look and you could ask, well, where is this happening? I think you're going to get within the corporation. I think you would get a very different. I think you would sense a very different level of commitment if, for example, human rights compliance was headed up by someone in the public relations department versus someone who reported directly to the CEO, right, or the CFO or whatever. And I think you could probably draw inferences about how a company is thinking of that, whether this is sort of like just a greenwashing kind of thing, or whether this really is a fundamental commitment by the company by looking at those kinds of things together with those statements. Yeah.
Great. And then, David, I also had another question for you that's actually a great segue, because your presentation touched on every aspect of the lawyer's duties that I talk about in professional responsibility. So it was a fabulous overview of a lawyer's responsibility, and especially an in-house lawyer. But what I wanted to ask kind of your advice on is, how does an in-house lawyer deal with the tension when lawyers are often known for kind of providing a note of caution, right? Warning against things that maybe the CEO wants to do, or the business leaders want to do. And especially when the lawyer sees not just, well, usually both, right? So usually sees both legal risks to the corporation and also ethical risks if the corporation proceeds down the path. So how does a lawyer balance kind of their employment needs and their position within the corporation and wanting to maintain that with their need to be able to give unbiased, unfiltered advice, and sometimes very strong advice that leadership doesn't want to hear?
Yeah, I think that's the problem, particularly like with in-house lawyers. You become like the party of no, and you become like everyone. You're the person they go to only if they have to, right? They just want to avoid your office as much as possible because the lawyers always tell you no. I think some of that is, I think by training. I think maybe by temperament, lawyers tend to be a little more risk averse. In law school, I mean, think about what you studied for 3 years in law school. You study failure, right?
True. It's true.
You study breaches of the social contract in criminal law where people hurt one another. You study wills that didn't work. You study business transactions that failed. That's what the cases are, right? Every case is a description of failure and how the law responded to it. I think that has an effect, right? Your tuition dollars at work, by the way. I think that has an effect, right? And so lawyers become very, very good at predicting and seeing what will go wrong. And also lawyers, and this is the reason other professional services haven't really made much of an inroad in the legal profession, become lawyers, only really trained lawyers can accurately predict how a judge will decide a case. Other professions cannot do that with anywhere near the same degree of accuracy. So it's valuable. It's a valuable skill. The problem is that it's taken too far, and it needs to be really confined within its particular realm. So I think the hardest thing when someone goes, for example, from the in-house, from a legal function over to the business function, they have to kind of unlawyer themselves in a way, right? They have to start to think about risk in a different way. I mean, I teach at a college that's focused on entrepreneurship, and about 20% of our graduates, 15-20%, go out and start businesses. I mean, that's what Babson does. That's our thing. So they look at risk in an entirely different way. But I think the thing is that probably the better advice would be to look to someone who's done it successfully. And I think one person who did it very successfully was Ben Heinemann, who was the former general counsel of General Electric for about 20 years under Jack Welch. And he is the person who actually created the modern in-house law firm to transform a legal department from being this sort of manager of outside counsel and the place that people went if they couldn't make partner to a place people actually wanted to go. He's the one who really drove that transformation, which is really, that's the new thing. That's the wave. He was ahead of his time. He said two things. He said the lawyer fundamentally has two responsibilities. Number one is you are the chief legal advisor to the corporation, and you need to push back on the business types in order to give correct advice. If you need more time, you tell them I need more time. If there are things that are illegal that would get the company in trouble, you need to tell them that. And you cannot facilitate bad behavior. And if you're in a company that insists on going ahead doing something illegal anyway, then as we talked about, you need to get out of there. You can't do that. You have other obligations. But you are also the guardian. That's part one of your job. The other part of your job is you are the guardian of the company's reputation. Right? That is your responsibility to make sure. And I think that has significant marketplace implications as well as just sort of normative implications as well. So, yeah.
So let's open it up now for questions from the audience.
Yeah, Professor David Nersessian, is that the way?
Yes.
Yeah, I like that expression, unlawyer yourself. I like that. I'm a retired federal administrative law judge and former Assistant U.S. Attorney Daisy Collins. On the last sentence in the data says that you are working with a major global hotel chain on a case study about the hospitality industry's effort to combat human trafficking.
Yes.
Would you comment on that, please?
Well, the identity's confidential, so I can't say who it is. But the idea is to sort of is to think about within the problem of human trafficking. Oftentimes, hotels are really right at the intersection of that. It's a place where it plays out, but not necessarily in the way you think. People think it's the hotel room and being complicit, that sort of thing, and that's where violations are taking place. It's actually less there than it is in instances where you basically have sort of wage slavery, where people in other countries can't get a job unless they go to a job broker, and a company can't hire anyone except through a job broker. And so people will go and they'll say, okay, I have to pay the job broker $1,000, and they're essentially indebted. So it's a form of indentured servitude. That they're seeing it in that respect, and they're also seeing it in the construction industry, where new hotels and that kind of thing are being built, where basically people are being brought in from other countries, put in horrible, horrible conditions, and basically it's another form of indentured labor, effectively. Yeah.
Yeah, I mean, I understand you can't reveal the name, but is this going to end up with a book or a written report, or what's it going to end up with?
It'll be a case study. Yeah, it'll be a case study that'll be available for teaching purposes. Yeah.
So it'll be
published, yes.
So we'll know.
Absolutely, yes.
Okay,
Yeah.
thank you.
Hi there. My name is Douglas Plawa, and I'm a second-year student here at Case Western. One of my questions, and is just kind of to see what your thoughts are on this, that you see in the news all of these corporations that condemn actions, and my concern is that it's just mere virtue signaling. And what you kind of touched upon it a little bit, I mean, putting it to action. And my question is, do you think that these, for moral, not necessarily human rights violations, because I think most of us can come to agreement as to, child labor is obviously, an atrocious behavior. But with respect to moral and social responsibility, do you think you have to be all in as a corporation? I mean, supply chain, everything, or not? Because when I see companies like Nike condemn certain actions, I don't know if they made comment on the president's remarks about DACA and whatever, the administration's going to do on that. But it wasn't so long ago when their atrocious working conditions to produce their shoes came out. And or even companies like Amazon, for example, with the new headquarters that they want to do, you start to hear all these stories that, well, when Amazon moves in, housing goes up, gentrification happens, all of this, and then at the other side of their mouth, they're saying, we condemn this atrocious behavior, blah, blah, blah. I'm wondering what your thoughts are on, do you pick and choose your battles? Because then you can essentially be a hypocrite, by saying on the one hand you care, and on the other doing something completely contrary to that. So is there a balance? And that's open to anyone up there.
Well, I'm going to answer this with the words of John Ruggie, the former UN Special Representative on Business and Human Rights. He was very clear, and I totally echo what he has stated, namely that good deeds are not going to make up for harm you do. So that is all great, right? But it is very important what I just talked about today. This is not a substitute for a robust compliance system, for monitoring your supply chain, for an effective due diligence system. That is a completely different, it's kind of the other side of the equation, if you want, of the corporate responsibility, the corporate human rights responsibility, right? One element is the responsibility to respect human rights. And that is exactly what you just described, right? Do not be complicit in human rights violations through your supply chain, human trafficking, working conditions, even, you know, gross violation of environmental standards, right? Think about BP. Corruption issues is also an area of corporate responsibility. And then the other side, which has not really received that much attention, right, is, well, the corporate human rights responsibility, or the corporate responsibility to not just respect human rights as a baseline, a mandatory, indispensable baseline, but to be ideally incentivized, and that's where the drivers come in, right, and incentives, to actually go beyond that baseline standard, because let's face it, right, we've heard it this morning, where yes, deterrence is a very effective way of changing corporate behavior, but it's also extremely resource intensive, right? I mean, it's very resource intensive. You need a lot of institutional enforcement to actually do that. Imagine you have an organization and you need to really monitor and police every actor at all times on all tasks they are doing. That's not going to be very functional for your organization, right? So I think it's kind of, we have to get out of this paradigm of it's either or. It has to be both.
Can I also add? I think the other thing that you're identifying is that we can all agree, I think, about reputation as a driver and the value of reputation and how it's closely connected with what we identify as CSR. And I think what you're pointing at is looking at these moments of corporate public policy making, whatever, is not as isolated moments, but part of a macro environment. And so once again, playing the role of skeptic, you know, I'd be curious about, is this serving some kind of reputational repair function because it's something that happened before, or is this a way to build up reputational capital for something they want to do in the future? So.
Great. And I think we are actually out of time here. I think we're supposed to end at 1, so I think we'll have a short break and then the lunch presentation. Thank you so much to my panelists. That was really great.
Really interesting stuff. I want to read your case. I hope it's contact.
That'd be great.
That'd be